By the year 2026, the historical link between search volume and website traffic is expected to completely fracture beyond repair. As search engines evolve into answer engines using generative engine optimization, or GEO, they synthesize legal advice directly on the search page. This creates a dark AI environment where source attribution is obscured. This chart tracks organic click-through rates for traditional search results. We are seeing them plummeting by 61% because users are finding their answers without ever clicking a source link. Investing heavily in traditional SEO and the digital hunting of leads is becoming a mathematically failing equation. The traditional lead pipeline is simply being swallowed by the search interface itself. Many firms attempt to retreat to legacy models, specifically relying on the charismatic rainmaker, a senior partner whose personal social capital drives the firm's growth. But relying on individual networking carries a massive institutional risk. When that rainmaker retires, the pipeline immediately dries up. To survive the rise of generative AI, firms have to stop fighting the algorithm. They must mathematically scale by activating the one asset an AI cannot intercept: the firm's existing client base. Activating a client base through referral marketing sounds straightforward, but in the legal sector, it is a complex ethical maze. Traditional retail markets deploy financial incentives and gamified loyalty programs with zero friction. The legal profession, however, operates under strict prophylactic oversight, designed to protect vulnerable consumers from coercive marketing. Any referral strategy in the United States must strictly adhere to the American Bar Association Model Rules of Professional Conduct. Deploying standard retail referral mechanics carries a severe risk. Offering a cash bounty for a lead can cost the partners their licenses and result in disbarment. The strictness of these rules exists for a precise reason. A referrer's commercial interests cannot be allowed to supersede a client's legal interests. The lawyer's independent professional judgment must remain entirely insulated from financial interference. The foundation of this oversight is ABA Model Rule 5.4. It strictly prohibits lawyers from sharing legal fees with a non-lawyer. Because of this, mechanics like direct cashback rewards, buy one get one free coupons, and referral sweepstakes are entirely off limits. They compromise client interests by incentivizing the referrer to chase a payout. Furthermore, ABA Model Rule 7.2 maintains a historical ban on paying anyone for a recommendation, designed to prevent stirring up unnecessary litigation. But within modern iterations of this rule, there is a vital exception. Rule 7.2b.5 permits a lawyer to give a nominal gift as an expression of appreciation. The ethical distinction here relies entirely on timing and intent. A firm cannot offer a transactional bribe to generate a lead. They can, however, offer a routine courtesy to say thank you. Prospective compensation is an illegal bounty. Retrospective gratitude is a fully compliant expression of business hospitality. Human memory is an unreliable tool for Rule 7.2b.5 compliance. Executing this strategy requires a strict, automated CRM workflow. When a new client is retained, the intake system seamlessly attributes that lead to the original referring client, categorizing them as an ambassador. Here, the system enforces a mandatory delay. It waits weeks or even months after the initial referral has been processed. Long after the dust settles, the firm dispatches a surprise nominal gift, typically valued under $50. There are no published reward tiers and absolutely no prior agreements. This deliberate delay proves the gift is an act of pure appreciation, allowing the firm to systematically reward their network while completely shielding the partners from fee-splitting violations. If every current client refers just one new client annually, a law firm achieves 100% organic growth. Yet data shows that while over 80% of satisfied clients are willing to refer, less than 30% actually follow through. This gap is caused by social risk. When a client recommends an attorney to appear, they put their own professional reputation on the line. They worry about looking like a compensated solicitor. A standard referral program actively worsens this dynamic. If the reward only benefits the person making the referral, the interaction feels mercenary and self-interested. The architectural solution is to build a double-sided reward. In this structure, the tangible benefit bypasses the referrer entirely and is given directly to the new prospect. By directing the financial value, like a waived consultation fee, straight to the potential client, the firm avoids paying a kickback to a non-lawyer, elegantly bypassing Rule 5.4. More importantly, it neutralizes the social friction. The referring client is no longer soliciting on behalf of the firm. They are providing an exclusive, high-value benefit to their personal network. Overcoming hesitation requires structurally validating the interaction for the referred friend. When you make the referrer look like a benefactor, they share aggressively. Determining exactly which rewards will motivate a specific client base requires moving beyond standard marketing assumptions. High-performance firms deployed dynamic, branching diagnostic surveys, often utilizing the ask method, to uncover hidden client pain points. These surveys frequently reveal that clients are focused on adjacent problems. For example, couples drafting prenuptial agreements are usually far more stressed about the logistical chaos of wedding planning than the legal nuances of the contract. This insight allows the firm to deploy knowledge assets. Because expertly curated information carries immense intrinsic value without an explicit price tag, it functions as a highly motivating reward with zero transactional stigma. For those family law clients, the firm does not hand out a promotional brochure. They gift access to a meticulously curated mobile directory of vetted local venues, florists, and photographers. In a business-to-business context, a firm might analyze executive survey data and respond by gifting specialized AI governance frameworks or GDPR compliance updates right to their clients' mobile screens. Because the average consumer's social network spans roughly 200 people, sharing a high-utility asset triggers a massive reach multiplier. This regifting phenomenon projects the firm's authority to hundreds of qualified prospects through a single referral. Expertly curated knowledge assets allow a firm to project market authority directly into the hands of thousands of qualified prospects, completely bypassing search algorithms while maintaining absolute ethical integrity. As a firm scales this ecosystem, it can look toward broader retail mechanics, provided they are adapted with surgical precision. Offering steep digital discounts for routine, commoditized services is permissible, but advance funds must be parked in a client trust account until earned, with a strict mandate to refund the money if a conflict of interest prevents representation. Gamified loyalty points, while common in retail, are highly inappropriate and potentially unconscionable when applied to trauma-based services, like criminal defense or personal injury. Instead, firms secure predictable, recurring revenue by offering subscription-based advisory models to their corporate clients. These VIP access tiers must strictly adhere to federal guidelines regarding transparent cancellation and deceptive auto-renewals. Integrating any retail mechanism requires viewing the strategy entirely through the uncompromising lens of fiduciary duty. This creates a self-sustaining cycle. Diagnostic surveys drive the creation of knowledge assets, which trigger organic regifting. This generates new, retained leads, triggering an automated CRM delay that concludes with a compliant, retrospective gift. Participating in an increasingly expensive bidding war against opaque generative AI search algorithms is a race to the bottom. Modern law firms have to abandon their old playbook. They must stop the digital hunting of strangers and start systematically farming the trust that is already present in their client base. This closed-loop ecosystem can be expanded even further by establishing transparent, non-exclusive referral networks with aligned professionals like CPAs and financial advisors. By marrying strict ethical compliance with diagnostic behavioral data, the firm activates the most powerful growth engine in existence: authentic human connection. In the era of synthetic search, the ultimate goal is no longer to be found by a machine. The only impenetrable moat a firm can build is a delighted, empowered, and thoroughly activated client base.